All right, we'll call to order the Planning Commission tonight, August 30th, 2022 at 6 p.m. First thing on the agenda here is to do a roll call.
Mr. Dapes,
Here?
Mr. Mahousen,
Here.
Mr. Sarah,
Here.
Mr. Volas, Mr. LePage.
Here. Okay, next on the agenda is to submit the June 1st, 2022 meeting minutes for approval. I would like to make a motion to table this item since Mr. Volas is not here tonight.
I'll second it.
We have a motion and a second. Roll call, please, Randa.
Mr. Sarah,
Yes.
Mr. LePage,
Yes.
Mr. Mahousen,
Yes.
Mr. Dapes.
Yes. Okay, next on the agenda is to submit our August 3rd, 2022 public meeting minutes for approval. Exhibits 1 through 11 were attached, and exhibits 12 and 12A were hard copies given. Would entertain a motion on this.
Motion to approve as submitted?
I'll second. Roll call, please.
Mr. Mahousen,
Yes.
Mr. Dapes,
Yes.
Mr. LePage,
Yes.
Mr. Sarah.
Yes.
All right. Next on the agenda is the adjudication hearing continuation of application number 22NCPC-0008, Wolpert Inc., 1445 North Main Street, North Canton, Ohio 44720. It's a conditional use permit for a gasoline station accessory to retail on a parcel larger than 5 acres in the MS-NG zoning district in accordance with ordinance 24-2022. At this point, I'll pass it over to Mr. Boyer.
Thank you, Mr. Galpace. I'd just like, before we get started tonight, just to give a brief reminder about the adjudication hearing. For those of you that were here at the last meeting, this will be duplicative, but for those of you that are here this evening, just so you know, contrary to our general public hearings, an adjudication hearing is, it's like a court hearing. So it's not a situation where the public can come up and discuss things that are their opinions. It's a fact-based hearing. Anybody that desires to speak tonight will be sworn in. When you do so, please clearly state your name and your address for the court reporters over here. The hearing is being run by the hearing examiner, which is me this evening. Each of you who are sworn in are subject to questioning and cross-examination for the Planning Commission, from the hearing examiner, and from any counsel that is here this evening on behalf of the applicant or others that are interested in the project. Please limit your testimony to factual-based evidence. Evidence that is subjective in nature or that's an opinion is unfortunately not something that can be considered here. We have to just consider probative factual evidence, not unsubstantiated opinions. At the conclusion of all these witnesses and all the presentations from all parties here, the Planning Commission will review the facts presented in accordance with various provisions in the North Canton Codified Ordinances and make a determination related thereto. And with all that said, I'd like to turn it over here. I will lead off with Attorney Swing. We ended with you on the last hearing. Do you have anything further to add or any statements related thereto?
May it please the Planning Commission, Christopher Swing, here on behalf of Albrecht Incorporated, 1474 North Main Street. I'd like to reserve the right to cross-examine any of the witnesses that may be called this evening. I'd also like to reserve an opportunity to present a closing argument this evening for the Planning Commission. It won't always be strictly, as you put it, I think, fact. I mean, there's some legal questions here, right? And there's some legal arguments to be made, so I'm going to reserve the right to make those arguments as well. Thank you.
Understood. Thank you, sir. Okay, so next in the process, so it was a little different from last time. Typically, the applicant and all those associated with the applicant would speak in favor, and then anybody else would speak. In this situation, Attorney Swing requested, and we granted him the right to present at that point. So is there anybody on the applicant's behalf or any other interested party that has any facts or witnesses to present at this time?
Mr. Chairman, members of the commission, my name is Majid Maklouf, and I'm legal counsel here for the city of North Canton. And we witnesses would like to. And I will also add, obviously, opinions of lay opinions are inadmissible, but we take the position that expert opinions.
Yes, sir.
And where would you like the witnesses to be?
Let's see, last time they spoke generally from kind of the back left corner. Does that work for both court reporters? If they speak generally kind of next to chief, basically? Okay, let's put everybody back there.
Okay, we call Mr. Sean Suter.
Come forward, sir. No, sir. Thank you.
Thank you very much. Suter, I know you're in the timeout slot. We'll start, if you can please identify your name.
My name is Sean Suter, F-U-A-N-S-U-D.
And Ms. Suter, what is your educational background?
I have a Bachelor of Urban and Environmental Planning, from Virginia School of Architecture, and Juris Doctor from Virginia School.
And what is your current occupation?
I'm both an attorney licensed in Ohio as well as a consultant. Called Suter LLC. It's at 455 Avenue, Suite 203 in Cincinnati, Ohio. 52226. And I have a zoning consulting company called ZoneCo at the same address.
And what does zone code do?
ZoneCo consults with local governments around the country to write zoning codes, rewrite their zoning codes. Generally advise governments on that.
And what's the scope of your practice in the state of Ohio?
Generally, commercial real estate, land use, and zoning law.
And I mean, in terms of drafting and assisting municipalities with code, what's the scope of that?
Well, we've worked with numerous local governments in Ohio, in all parts of the state, numerous governments in East Ohio, Central Ohio, Southwest, Northwest, all over, big and small.
Have you had any involvement with the city of North Canton?
Yes, I was hired, firm was hired, my prior firm was hired, I should say. I was with Griswold, Cincinnati office, Cleveland firm. I ran a subsidiary called Capital Zoning, and we were hired by Canton to assist in making some amendments to the zoning code.
When was that?
I believe it was 2018.
And what did you do in connection with that engagement?
The focus of the engagement was to take a look at the existing zoning and propose new zoning for the Main Street corridor from the city line to the south and the city line to the north.
And did you end up recommending any changes to the zoning code?
Yes, the zoning that was in existence, I believe was on Main Street. I can't remember the name exactly, Main Street B or Business, Main Street Business, something like that. It was.
We can take a second.
Yeah.
The podium is being called.
Great, thank you.
All right, Mr. Suter, go ahead.
Okay. The Main Street zoning that was in effect on Main Street at the time was what I would call Euclidean zoning. So it's sort of a one-size-fits-all zoning. Areas, I believe, in the city. I don't recall exactly. It treated the entire Main Street for same zoning purposes. So we took a fresh look at the corridor, identified the various different development patterns and character along that corridor, and we proposed 5 new Main Street districts that are geographic-based districts. Call it development pattern districting. Essentially, you district around unique development patterns, distinct development patterns along Main Street.
And was there a public involvement process through that rezoning?
Yes.
What kind of public process did we have?
Well, it went through the public hearing process, I know. I was not in charge of the engagement portion.
I'm gonna hand you what's, I think the applicant, the opponent went with the numbers, so I'm gonna use alphabet. So I'm gonna hand you what's gonna be marked as Exhibit A, City of North Canton Exhibit A. Do you recognize this exhibit?
Yeah.
Do you understand it?
This appears to be chapter 1136, the Main Street District Regulation of the zoning code.
And is this the chapter that we've had involvement with helping the city amend? Let's go to section 1136.05. And I see there are different classifications. There are MS-C, MS-NG, MSN, MSS, and MS-SG. What do those classifications?
Those are the 5 new geographic-based zoning districts that make up the Main Street corridor from the south city boundary to the north city boundary. MSC, well, if you think about Main Street, there's the center part called City Hall District. That's the MSC, the Main Street Center. And then think about how it gets less dense, less pedestrian oriented as you go out. So there's the Main Street North of the Main Street Center, the Main Street South, just south of the Main Street Center. And then you have the 2 gateways, Main Street North Gateway, and Main Street South Gateway.
And what were the objectives in trying to come up with the permitted uses and conditionally permitted uses for the different districts? Were they all the same, identical for each district, or do we have deviation?
Every district is treated as its own unique place. Even though it's all connected as one corridor, the idea was because they have distinct development patterns, we wanted to calibrate standards to further those distinct patterns. So, Street Center, we wanted to foster a pedestrian-oriented, dense, you will, first floor retail, first floor commerce, with a residential product to create some note of activity for pedestrian development.
How about the North Gateway District? What were the objectives there?
So the North Gateway presented some challenges because you have the Kmart. I think when I first started consulting here, Kmart might have still been open, but it closed pretty quickly after I started here. So that particular area, Main Street, is the least walkable, least pedestrian oriented, most auto oriented Main Street.
And did the permitted uses in that district reflect the auto orientation of the district?
Yes, that's what we calibrated to that area. If there was anywhere along Main Street that auto-oriented uses were going to be appropriate, it was in that North Gateway area.
So to clarify for the commission, so for instance, I look at one of the categories, distributors, warehouse, and wholesale. When it says NP in the central district, that means not permitted in the central district,
That is correct.
but it is a permitted use, for instance. Is that because of an auto orientation?
Yes, and the scale of the buildings. North Canton building, unique, you have a huge building in the center of town. The rest, the old Hoover facility. But you have, on the other side of the street, very pedestrian, small scale development. And as you go north, south, it also has fairly small scale development. Gets a little more auto oriented as you go out. The reason that you wouldn't you would allow a warehouse or distribution center in North Gateway, is just the scale of the buildings up there are much larger. You know, one thought might have been to repurpose the Kmart in some way, it would have possibly been for distribution and warehouse. And so you would calibrate uses that reflect the scale of the development there, that's on the ground, and developments, along with the transportation network. So that area has big wide roads and is much more auto oriented. So these types of uses focused on automobile and pedestrian. You don't see many people walking in that part of town. I'm sure they do once in a while, but it's not.
How about, I noticed, for instance, new car sales is only permitted in the North Gateway district.
That's correct. The, again, the North Gateway was the concentration of more of the suburban scale. The South Gateway is not the same. It's a different scale. There's residential there. There's as you get closer to the town center, it becomes a little more walkable, pedestrian scale, urban, town center. That's your, you want to call it an urban core, that's your.
And how about, I see that, by the way, sorry, do you know where the Meyer project was proposed to be, in which district?
My understanding is it's in the MSNG.
Okay, but the more pedestrian, the more auto-oriented district that we've been talking about.
That's
And then I see that one of the uses, if you look at the very last use listed there, gasoline station when accessory to retail use as a primary use on 5 or more acres. You see that?
at the very bottom, yes.
Yeah. And then it says A, comma, C. What does that mean?
That means that it's treated as an accessory use, but it's also a conditional use.
And how do you determine if the use is a principal use versus an accessory?
The principal use is going to be the primary use. Main thrust of the land use on that property. It would take up most of the space on the property. An accessory use is incidental by definition. Typically customarily incidental is how it's defined to a principal use, but it is dependent upon the principal use.
Can you give me examples of accessory uses that are usually associated with retail?
With retail, the most common one associated with retail, the gas station these days. Convenience store, something in the outline.
And in your years of experience, have you, I understand you've worked in developing the zoning code, but you're also, do you have experience in working on developments, watching developments happen?
Yes.
And what happens if the accessory use is on a different parcel than the principal use? What happens in those situations?
With respect to purchasing or zoning?
Zoning.
Well, you would go in and try to get the approval that you would need for principal use and accessory. And buy the properties.
And trying not to, how normally in your experience, when a developer goes in and tries to purchase property, is it typically always owned by the same owner?
No.
They would compile a parcel out of multiple parcels from different developers, right?
Sometimes, yeah.
And the traditional developer, I understand there are always exceptions, but traditionally, would the traditional developer close on a purchase before they have the zoning approvals in place?
Not typically, no.
And then how do you get an accessory use approved and to be able to close on a building before you have your parcels in place?
Well, you would need to bring it forth as, for the building. Get it all entitled at one time. You have a contingent contract, government approvals period, you have to get all your approvals finalized beyond the applicable appeal period, and then once you have some, close on those.
And is the consolidation plat then filed after? At that point?
It can be typically, depends on who's responsible in the contract, but, it could be, it could be a closing. Yeah.
Okay, but it happens after the zoning appeal, I guess.
Yes, that's right.
And you, what's been marked, the city of North Canton, exhibit B. And this exhibit has already been used in the record, so I won't go through a long identification of it. But in drafting zoning regulations, do you also draft regulations governing conditional uses?
Yes, we'll also draft the administration procedures, chapters of the code, include any kinds of approvals that could be granted, conditional uses, special exceptions, variances, zone change.
And if I take you to section 1145.02, subsection C, in the criteria for the conditional use, I think it reads, will not restrict or adversely affect the existing use of the adjacent property owners. What does that language mean to somebody who drafts these codes?
In other words, the conditional use approval is really sort of balancing public and private interests, benefits and all that. So that's what these standards are trying to get to. This particular standard, I think of, when I think of this standard, I think of church going in the residential. Usually that's a conditional use, because you have to take a look at it and say, is this going to be compatible with adjacent land uses? That's the residential. Compatible, not that it's, really intense use, but it can be because of traffic. So what this is trying to get at is, someone brought that church in a residential zone, you would need to look at how it's all situated, how it's being used, hours of operation, all those kinds of things to make sure that it's not adversely affecting existing uses, which are the residential in that neighborhood. This actually comes up quite a bit with the religious uses. Working on a project right now where seeing a large influx of Orthodox Jews, same kind of thing, right? So setting up a shul in your neighborhood, it's a conditional use. Is that going to create externalities or issues? So that's what you're looking at.
Is the limitation of competition a proper function of zoning?
No. That's not something that we look at or think about. In fact, usually you have clusters of uses together in places. Think of the gas station, thing. CVS and Walgreens will often locate right across the street from each other in the corner. So that is not something that we look at.
And have you ever seen language like subsection C applied to limit competition?
No.
Thank you. I will turn over the witness. I'd be happy to. I have more witnesses, obviously.
Thank you, Machine.
Thank you.
Good evening, sir.
Hi.
Chris Swing. Yeah. Your last name, could you spell it for me?
Suter, S-U-D-E-R.
D.
No, one D.
One D. Oh, I got it. Okay, thank you. Mr. Suter, did you have any involvement with amendments to the
North Canton zoning code in 2022.
Yeah.
Are you aware of the fact that the zoning code was amended in 2022 with respect to the North Main Street, the Gateway District?
I was not involved, I was not.
Not aware of that. Are you aware, sir, of the resolution number 2-2019 that was adopted by the Community and Economic Development Committee in 2019?
I'd have to see it, a lot of stuff flying around at the time, so I think you can provide a copy.
Council has Exhibit 8 from the last hearing. Mr. Boyer, are you able to provide that document to the witness?
See if we have it.
It's marked as Exhibit 8.
There on the screen.
Okay, very good. Screen override. Are you able to see that, Mr. Suter?
Yes.
Take a moment to review that if you would. You agree that in 2019, the city saw fit to restrict gas stations? Main Street. Section 1 and Section 2.
Yeah, is that, Hallam Southwest, on the street northwest, is that? I'm not sure exactly where the streets are, so I don't know.
That's fair. Do you know whether prior to 2022, whether gas stations were conditionally permitted use in the North Main Street or Gateway District?
I just want to put a continuing objection on the record that the question before the planning commission is not the rezoning of the property. The zoning is already in place. This is for a conditional use under the existing zoning classification, but I don't want to interrupt the witness. I'll just put the continuing objection on it.
So noted.
I'm not aware of that,
Okay.
focused on gas station.
Okay. Do you know that in 2022, there was an amendment passed specifically with respect to North Main Street, the North Gateway District, to allow gas stations as a conditionally permitted use?
I was not.
You mentioned overall pedestrian friendly. Let me ask you something, sir. In 2020, would you agree that there was an auto orientation still in the North Main Street, North Gateway District?
You mean the development
Yeah,
pattern there?
development pattern, yes, sir.
Yes.
Okay, and that really hasn't changed, has it, from 2019 to 2022?
I just drove around before the hearing just to take a look at it. It appears about the same.
Okay, but notwithstanding the fact that it's the same, right? Gas stations were prohibited in 2021, and now they're permitted in 2022. But you're not aware of that change?
I was not.
Okay. Now, when we look at 1136B, you have that exhibit in front of you, I think it's Exhibit 1. Actually, I'd like you to look, sir, with me at 113601A.
Yes.
Are you familiar with that provision?
Yes.
Okay. And that provision speaks to the general characteristics that the city would like to see on North Main Street, correct?
That's correct.
And that's true with respect to all 5 districts, right? Take your time. It says in paragraph A, it references each and every one of those districts, right?
The Main Street districts, yes, that's correct.
Okay, and so in each of those districts, it was the city's intent, right, to promote, for example, B1, a mixture of storefront, retail, professional offices, and dwelling units located in residential buildings and in the upper stories or rear and mixed-use buildings. You see that?
I do, yes.
And it doesn't distinguish, does it, between the 5 districts?
It does not.
Okay. That's true with respect to items 2 and 3, right? Under B?
It does have to do with the orientation of buildings. That's correct.
Okay, so regardless of how you characterize the main central area as being more pedestrian friendly, the zoning code itself doesn't distinguish with respect to these 3 items, does it, under B1 and 3?
Objection.
I think,
You can answer.
I think that the concept was to intensify the district. In different ways, though, but to infill, it was an infill code essentially.
That, sir, it's a very simple question. Does the code distinguish in that section?
In that section B, no.
Okay, it applies to all of them, doesn't it?
Let's say the Main Street districts.
Okay. Have you by chance seen the traffic study that was prepared for the city? Have you seen the phase 2 environmental studies that were performed on the underlying properties? Do you agree that there are instances when gas stations operate independently of any other use? Have you seen a copy of the purchase agreement?
I have not.
Can you identify for me what documents you reviewed in preparing for your testimony this evening?
The zoning code, this particular chapter.
Anything else?
Oh,
Did you review the application?
I did not.
Did you review the preliminary plans?
I don't believe I received them.
Okay.
Yeah, I asked for them.
Did you, okay, you asked for, but were there other things that you asked for and you didn't receive?
Not.
Did you by chance review the transcript of the August 3rd adjudication hearing? Did you review the YouTube video that is being taken?
I did.
Nothing for, thank you.
Just a few follow-up questions. Mr. Studer, just a couple of questions. Do municipalities amend their zoning code often?
Hopefully, some do. A lot of times they sit on the books for 70 years, which is why we have. But generally speaking, diagnose zoning codes, I always look at each provision to determine when it was last updated, and it's really informative for us. And it's usually piecemeal updated, so there are amendments frequently. Codes.
And do the amendments reflect vitality in the municipality versus places where the zoning code has been dormant for years and years?
Well, I think the zoning code, and we always preach this, needs to be a living, breathing document. It should not be something that's written in stone for 70 years. It needs to be updated as the market changes, as conditions change, as the world changes around us. One example that we've done a lot recently is because of COVID, people are looking more at drive-up windows, walk-up facilities, not and drive-throughs. It used to be, and communities would come to us and say, ban drive-throughs, we can't stand drive-throughs, no more drive-throughs. Now it's bring us drive-throughs, walk-throughs, drive-up. So yeah, I hope that communities are responding to reality on the ground.
Thank you. And then Mr. Swing asked you about the intent provision in section 1136.1. Are you familiar with the idea of the specific versus the general in the code, the differences between? Can you explain that to the commission, what that means?
Well, the specific tends to, in terms of legislative interpretation, the specific tends to come to look at specific language.
And is the language in 1136.01 the general language? Or is that specific language as compared to 1136.05?
Language, purpose and intent language. It's supposed to give a general overview. It's not regulatory language, it's more introductory type language.
And how about the specific the schedule of permitted uses in section 1136.05? Is that regulatory language?
Yes, that's specific.
And I think the question was that the intent language, the general language applies across the board. Is that the case in the specific language in 1136.05? Or are there different uses for each category?
Oh, different this is calibrated to specific uses in specific districts to achieve the desired outcomes.
And if I could just have you, in 1136.01, because I know that the emphasis here has been on urban walkable fabric. But when I read that language, and I'm curious to you to provide me more input in terms of what was meant there, because it says these districts are established to promote the development of higher density, more consistent walkable urban fabric and attract increased investment. What does higher density mean?
North Canton is built out for the most part. Established in a green field somewhere. This is an infill code. That's we were trying to actually create some infill regulations along the main street. Hopefully the city will eventually is shifting towards an infill code completely because there's really no new development. Greenfield, so the idea here was to, as we are infilling, redeveloping properties, infilling parking lots, redeveloping vacant buildings, that kind of thing, little car dealerships, whatever has kind of become somewhat functionally obsolete along the corridor, that we would look to intensify the development, especially in particular areas where we're trying to achieve a pedestrian scale development.
And would allowing a gas station at this location interfere with the walkability of that district as it operates right now?
That area was not intended to be a walkable district. I have a lot of thoughts about what to do in that area. One of them could be housing. It's commercial, you could add in housing in there, like higher density, kind of apartments, something like that. But that is not that was not intended to be pedestrian-friendly, walkable park Main Street.
So is the gas station at the site an appropriate use as an accessory use of that property? Appropriate use there?
From what I know of the North Gateway, and I call it auto-oriented, auto-dominated, regular focused, whatever you want to call it. I know there are drive-throughs. Starbucks a lot there. There's a drive-through there. McDonald's to drive through. I think it has multiple lanes, if I recall. There are other gas stations. There's like a CVS, I think. It is very much a suburban scale development pattern, and a gas station along with a large retail appears to fit in perfectly there.
Thank you.
Mike, I've just got a couple of questions.
Go ahead.
I think you said, Mr. Suter, that like every 60 years, the code should be updated, not once every 60 years, a little more frequent than that, right?
Oh, yeah, I hope much more frequently.
And does it surprise you, though, that you have a resolution passed in 2019 that is intended to restrict gasoline stations on North Main Street? Then you have a 2020 amendment to the zoning code that restricts gasoline stations on North Main Street, and then 2022 comes and there's a change to that only with regard to the North Main Street or Gateway District.
Yeah, I see that kind of thing. I think if the city is responding to the marketplace and may have something to do with changes in the world, I don't know what the legislative intent was, but it can happen.
It can happen, but does it strike you as unusual?
To allow a use and then not allow a use in a short amount of time, that's multiple years. It's kind of hard to say. Legislative bodies, what's unusual and what's not.
Because you can't say one way or another.
No.
You can't tell the planning commission one way or another.
Again, continuing objection, the zoning of the property is not before the planning commission, it's a conditional use under the existing zone.
Right. Would you take a look at 1136 again, please?
Yes.
Okay, and specifically, take a look at the, again, you were, You were saying that the North Main Street, North Gateway District was not intended to be walkable. Is that what you told the planning commission?
It was intended to be the part of Main Street that was appropriate for auto-oriented uses. Now, should it be connected? Yes, it should be connected to the rest of Main Street. I think it is, by sidewalks and things, and if it happens to be walkable, but it's auto-dominant.
Okay, and the transcript will speak for itself, but you just told the planning commission it wasn't intended to be walkable, did you? Right? That might remind us.
I don't think it was intended to be walkable. Like I said, it should be connected though. And if it becomes walkable, super, but it's not designed that way right now. Well, the regulations aren't set up for becoming walkable pedestrian.
That's not what 113601A says, is it?
Well, I think, like I said, I think we're talking about higher density, increased investment, walkable urban fabric is all part of it. It's all part of it.
Okay, so to say to the planning commission that it wasn't intended to be walkable when the actual regulation says it is. It's intended to be pedestrian friendly, to create a pedestrian friendly environment. That's a complete contradiction.
I don't know where you're gonna walk to there. I think if you were gonna build multifamily, that would be internally walkable. And hopefully it would be connected to the other parts of the district, but there's nowhere to walk to.
Okay, I won't belabor this, but let me ask you one more question, okay? 113605, on the schedule of permitted uses, all right? You see down there where it says 2022 replacement, right?
Yeah.
And then if you read on to accessory uses, which is the last section on page 5, you see that, sir?
Yes.
The very last item under accessory uses says gasoline station when accessory to retail use as a primary use on 5 or more acres. Ordinance 24-2022 effective July 22nd, 2022. Like just a little bit over a month ago, right?
Yes.
And it was changed to allow for an accessory conditionally permitted use in the Main Street North Gateway District only, correct?
Here's that way.
Not any of the other 4 districts?
No.
On Main Street, right?
Now, those would not be appropriate for a gasoline station, even accessory.
Are you, I'm sorry, for interrupting.
Okay.
Are you able to identify anywhere in the schedule of permitted uses, any other change that was made to 113605 other than the one that I just pointed out to you in July of 2022?
I don't see any.
Thank you, Mr. Stewart.
No further questions.
Any questions from the planning commission? This witness? Seeing none, you may be seated. Thank you, sir.
Chairman, we call Jim Smith.
Jim Smith.
Good evening, Mr. Smith. Can you please identify your name for the record?
Jim Smith. I live at 1276 South Medina Line in Wadsworth.
Hanging with the mark as the city of North Canton Exhibit C as an F. You can identify that document for the record, please.
Yes, this is a copy of my resume.
The resume is in the record, but let's go quickly through your background. What is your education?
I have a BS degree in geology from Ohio State, master's degree from the University of Cincinnati.
And if you can speak up a little bit so that the commission can hear you. What is your professional?
My professional background, I'm an environmental geologist. Been so since 1986. I worked in that profession. Since that time, I own my own environmental consulting firm, that was founded in 2002. Been at this for 30-some years.
And do you have any involvement with the Meyer project in North Canton?
Yes, we are Myers environmental consultant for this project, as well as we have been Myers environmental consultant on projects all around the state several years.
So I know we can get into the weeds of this stuff, but for the commission, just sort of the average person to understand, what are you doing on this project for Meyer, and what's the intended outcome of your?
So we're doing brownfield assessment and cleanup of the property. As the name of my firm implies, that's what we do. Brownfield Restoration Group is my firm. In a nutshell, what we provide as consultants is to take environmentally impacted properties, generally commercial industrial properties, whatever environmental impact there may have been, and then also plans and oversee their cleanup.
Are you familiar with the voluntary action program?
Yes, I am.
Can you again, is this project going through the voluntary action program?
It is.
What would be the end outcome of what you're doing?
The end outcome of what, of the voluntary action program. The voluntary action program is the Ohio EPA's brownfield program. It's the program they created to deal with brownfield sites, that is, contaminated commercial industrial properties. And it is intended to clean up those sites and bring them back into productive reuse. So the endpoint, what is the endpoint of the voluntary action program? The assessment and cleanup work that we do is compiled into what is called a no further action document that can only be prepared by a certified professional under the voluntary action program. I am a certified professional. We have another certified professional in our firm. Certified professionals prepare no further action after all of the assessment and cleanup work has been done that meets the voluntary action program standards. That is turned into the Ohio EPA for review. If the Ohio EPA concurs with the no further action documentation, they will issue a covenant not to sue for that property, which is the holy grail, the gold standard for cleaning up the property.
Have you been involved in similar projects in this area?
Yes.
Can you identify a few for the planning commission that they may be familiar with?
Well, in Mathland, we just a month or two ago, included a voluntary action, got a covenant not to sue on a Republic steel mill, several hundred acres. It was a huge, very complicated site. It took several years to get. So we're very pleased to get that, just as I said, a month or two ago. In Canton, we've done the Hercules, the former Hercules engine plant in downtown Canton. We took that through the voluntary action program, got a covenant not to sue, and it was redeveloped from an old factory into, it's now residential apartments. There was another site, the former National Metal site in South Canton, that is now the Stein Industrial Development. That was an old metal recycling dump kind of place for decades. We took that through the voluntary action program, got a covenant not to sue. It's now redeveloped into an industrial park.
And is the intent with the Meyer property to take it to the end where you'll have no further action letter and the covenant not to sue?
Yes.
When you are doing the work that you're doing, is there any adverse impact on surrounding properties from what you're doing?
Well, no, as a matter of fact, that what we do is intended such that there will not be. One of the main criteria of the Ohio EPA and voluntary action program is before they're gonna give a covenant not to sue on the site, they want to be absolutely sure that everything was checked so that there is not adverse impact. I mean, that's the whole intent of the program.
And in actuality, in reality, what has been the impact when you do something like this on the surrounding properties from the work that you do cleaning it up?
Well, it's, yeah, I'm not a praiser or anything, but it is positive impact in that you have taken what was an environmentally impacted property and put it into a form that can be redeveloped. So you've got productive reuse of the property. It does nothing but enhance the property value.
Thank you very much. No further questions.
Thank you, sir. Good evening, Mr. Smith. Do you have plans right now in terms of remediating the site?
Not yet, we're still assessing.
And do you have any sense of what the cost might be to remediate the site?
Yeah, we're still assessing. You can't meaningfully determine the cost until you're done with assessing.
What's the timeline sort of look like for assessing?
Myers has us on as fast a track as we can possibly go, and next 2 months.
Do you know ultimately who bears the cost of that in terms of either let me break it down. The remediation itself, do you know who bears the cost of that in this transaction if it goes forward?
Objection relevance.
You can answer the question.
Yeah, you may answer.
Do you know who bears the cost?
No, that presume either Myers or the city or both.
When you say the city, you mean the residents of North Canton, right?
I don't know. That's not my area of expertise.
Okay.
We do the work and we get paid.
Okay. The no further action document you mentioned, we're not anywhere near that at the present, right? We don't have we don't have a no
We
further
do
action.
not, at this point, have no further action document.
Okay, and the gold standard, as you put it, the covenant not to sue, we don't have that either, right?
That is correct.
How long do you think it might take before you reach the gold standard as you described it?
Would like to, think that we could be done with the NFA this late winter, submitted. And EPA generally takes 6 months to review and issue a covenant.
We're talking about, when you say late winter, do you mean February, March? Okay, and then another 6 months beyond that?
To get the covenant not to sue.
Okay. And then, so you're looking at potentially November of 2023? December?
Potentially, yes.
Okay. By any chance, did you read the transcript from the August 3rd adjudication hearing?
No, I did not.
Okay. At that adjudication hearing, I'll represent to you that Mr. Jones testified that, you know, they could put deed restrictions in place with respect to the actual conveyance ultimately to Meyer. Have you seen that before? Are you familiar with that?
I have not seen that.
You know, no potable water from the site, for example, is one that he gave. Is that something that you do with brownfield sites? Are there restrictions like that?
Yeah, that's very typical.
So it's not an industrial use we're talking about. We're talking about the general public coming to a Myers, right?
Excuse me, I'm not following the question.
It's a commercial use, correct?
A Myers site would be considered commercial, yes.
Okay. Does it shock you that there might be a deed restriction that would say no children's playgrounds permitted, even for a Myers?
It's typical in the voluntary action program that they have exceptions for certain uses.
Is that typical for Myers locations? You say you've represented Myers in other locations, didn't you?
Yes, we have represented Myers in other locations.
Is it typical to have a deed restriction or a restrictive covenant that would preclude or prohibit children's playgrounds?
Objection, relevance, and, this conditional use hearing is not about playgrounds, but about retail store.
You can
so-
answer.
So is it, I'm trying to understand the question. Would it be unusual for Myers to have a restriction? I would have no idea, frankly.
Okay, that's fair. Then I won't ask you any more questions about that.
Mhm.
You've done some assessment of the property currently, right? Okay, and you appreciate that as it stands, there are two separate parcels, one of which will house the accessory gasoline station, which we're here about this evening, right?
Objections to the characterization.
Yes,
Okay, and then there's a larger parcel upon which the supercenter will sit.
that's my understanding.
Okay, now, in your, at least early stages of preliminary assessment of the environmental issues out there, are the more serious issues, as you would characterize them, on the bigger parcel or the smaller parcel, as I just described them for you?
Definitely the larger parcel, yes,
So we're talking about the parcel that would have the principal use.
principally, the Myers store.
And so if I'm understanding this, then we're not gonna know until November or December of 2023 whether or not the principal use can even exist there and whether or not we'll be able to get to a point to reach that gold standard of covenant not to sue. Is that right?
Well, not exactly. They can, it's a voluntary action program. It's not a mandatory action program. They could build the building tomorrow.
But you started the ball rolling already, have you not? With
Toward the voluntary action, and toward an NFA and further action and covenant not to sue. Yes, we're on that. Absolutely.
I've no further, thank you.
Few quick follow-ups. This is not the right witness for this, I'll just make the statement for the record, because the evidence is before the commission in terms of the actual boundaries of which use goes over which parcel. The commission has the plan and knows that there's, it's not as clean as the use being on a very specific parcel, but, Mr. Smith, there's nothing, I think you've just testified. If a Meyer were to open tomorrow, would that prevent you from finishing going through the voluntary action program?
No.
And you could get the covenant to sue after?
Objection hypothetical.
Yes.
And does that happen in projects? And as the consultant working on the voluntary action program as you sit here today, do you see any reason why you should not be able to achieve the no further action letter?
Objection forward.
No, we've not seen anything that would indicate to us that it has a hurdle.
Thank you. Get into further follow-up.
I have one. Thank you, Majid. I just have one question. You just testified that you don't see any present hurdles, right?
Yes, correct.
Okay, but you also testified that the assessment's far from complete at this point. Is that right?
That's
Thank you, Mr. Smith.
Any further questions from the planning commission for Mr. Smith?
One question. You indicated Mr. Smith is a voluntary action program. So Meyer could essentially, through design and construction, build an occupiable, safely occupiable building on that property without that full removal.
They could. Yeah, it's not a regulatory requirement in order for them to build that.
This is above and beyond.
They want to do it because of liability protection. That would have for
No further questions, sir. Thank you.
Are you up here for
I would just keep them for future witnesses. Sir? Yeah. Thank you very much. At this point, we'd like to call Kevin Westbrooks. Identify your name and spell it for the record.
Kevin Westbrooks, K-E-V-I-N. Yes.
Mr. Westbrooks, what's your educational background?
I have a bachelor's of science in civil engineering.
And what is your profession?
I am a traffic engineer, practicing.
And in what firm are you?
I am with GPE.
And do you typically represent municipalities in that capacity? As part of your civic engagement, do you have any other civic engagement that's related to land use zoning?
Yes, chairman of the Macedonia.
Mr. Westbrook, so you've been sitting here hearing the testimony about the Meyer project. Are you familiar with this project?
Yes.
Have you conducted any analysis in connection with this project?
Yes, the focus being on the gas station itself, traffic study prepared by. I was looking at what kind of additional traffic is the gas station putting onto the roads. Using traffic industry standards, which is good transportation and trip generation. My calculations show that the addition of the gas station is adding approximately 15% additional traffic in the morning and 11% additional traffic.
Do you consider that to be significant?
I do not.
Do you consider that to have any adverse impact on the surrounding properties?
No, I particularly based on looking at the traffic study. Volumes that are out there.
Mr. Westbrook, can you speak up just a little bit?
Sorry.
Thank you. Yes, sir.
And do you think that any improvements to the roadway or any improvements that Meyer can do would remediate any impact if any were to exist?
Yes, and then their traffic study identifies.
Thank you very much. I'll turn over.
Thanks for coming this evening, Mr. Westbrooks. You said you were focused primarily on the gas station. Correct. You agree the gas station is going to be accessory to principal use there? Don't you think it'd be prudent to evaluate the overall project, not just the gasoline station in isolation?
The traffic study that the prepared does do that.
Okay, so I'm gonna hand you what's been marked for identification. I'm gonna, actually, the court reporter can mark it later. I'll hand write it on here. Exhibit should be 13. You have a copy of the traffic study? Sir, I'm handing you what's been marked for identification. It's exhibit 13. You're telling the planning commission that you did review that? Okay, but you didn't take it into account with regard to your specific testimony this evening?
what you meant?
Well, is it necessary for your analysis in evaluating the gas station to take that into consideration or not?
No. If I'm understanding it.
So it's your expert opinion this evening, you consider yourself to be an expert. It's your expert opinion this evening that the traffic study dealing with the Meyer Supercenter, that study, the one that was, I think, authored by Keegan Anderson, consideration of that study is unimportant for purposes of what you're going to testify about to in terms of the traffic for the gas station.
No, it is relevant. I mean, the study includes the gas station, and so I reviewed that, and I was trying to extract out of that any addition, what does the gas station do? How does it contribute to that study and the impact?
Do you know what the conclusions of the Wolpert study, do you know what those conclusions were?
Yes.
If you look at the last page, sir, page 18, see the conclusions of that study. It talks about the need for an additional signal at the intersection of North Main Street and Stratton, correct?
Correct.
Have you seen any specific plans to address that?
No.
Do you know whether Meyer has agreed to do that? Do you know whether or not the city's going to do that? When I say the city, I mean the residents of North Canton. Do you know who's going to take care of that from a cost section?
No.
How about the widened Stratton Street to allow for a left turn and a right turn lane? You see that, item 2 under intersection number 4?
I see.
Have you seen any specific plans to address that?
No.
Do you know who's going to bear the cost of that?
No.
Have you seen a purchase agreement between Meyer and the city of North Canton? All right, directing your attention to intersection number 9, that's item number 3. Construct an access driveway with one northbound egress lane, shared left, right, and one ingress lane. You see that?
Correct.
Have you seen any specific plans for that?
No.
Do you know who to bear the cost of that?
No.
Item number 4, construct an access driveway with one northbound egress lane and one ingress lane. You see that?
Yes.
Have you seen any specific plans for that? Do you know who's going to bear the cost of that? Sir, forgive me, I didn't catch it. I think you said the overall increase in traffic count in the morning you project with the new gasoline station being an increase of 16%.
16% on top of the traffic that the Meyer store itself is going to generate. So Meyer's going to add a certain amount. It's going to bump it up about 16%.
Okay, so do you know what the percentage amount the bump is going to be because of the Meyer Supercenter?
No.
You don't know what that percentage is?
No.
But this 16% is going to be in addition to that, whatever. Okay, and that's in the morning, right?
Yeah.
How about in the evening? Did you say 20%?
I said 11.
Okay, forgive me, I just misheard. 11%. And likewise, that's going to be in addition to whatever traffic count increase occurs because of the Supercenter. Is that right?
This increase is estimating how much the Meyer will generate a certain number. This will be 11%.
Okay.
Not 11% of the roadway traffic. It's 11% of the new traffic.
And do you know what the increase is on a percentage basis in the evening for the Supercenter? Okay. You said 16% is insignificant.
If I said insignificant, and that it's not a large number that you would expect to have large, far-reaching impacts.
All right, so do you stand by that testimony? Is it significant or not?
It is not.
It's not significant. Okay. Is 20% significant?
Based on this, no.
Is 25% significant?
We probably need to get into a range of maybe 100 vehicles, which would probably be a 60% increase before you might see a significant
So you,
impact.
okay, so you draw the lines at 60% as being a significant, 60% in addition to whatever the Meyer Supercenter was going to generate additionally, right?
That could cause an impact.
But you haven't done that today.
No.
the documents that you reviewed and preparing for your testimony this evening.
Just the traffic.
Anything else? And nothing else. Thank you, sir.
Mr. Westbrook's just to do follow-up questions. If you could look at Exhibit A, which is Chapter 1136. Is there any such thing as, maybe that's not, is there any such thing as a use that doesn't generate any traffic?
Not that I can think of.
So if we were to look at some of the permitted uses in the MS-NG district, that could be in place of the gas station. If you had a distributor warehouse, wholesale, would that have more traffic?
Jackson, hypothetical.
How about a use that's permitted as a matter of right? There's, or another use, car wash. Car wash have similar use to the gas station?
It's probably in a similar ballpark range, probably a little bit higher.
The car wash. How about I think you get the idea. The point of a call center, would that have?
Most likely larger, they're usually larger scale.
So we're talking in terms of relatives here, when you say something is significant versus insignificant. Am I putting that correctly?
Correct.
And can you just, one more time, so that the commission understands it, when we're talking about subset within the subset? Because I think when we say 11%, 16%, can you explain that a little bit more to the commission in terms of relative numbers, what we're talking about?
So, just throw out some ballpark numbers, the trip generation analysis, that's, typical standard for traffic impact study. So the store itself would be generating 493 new trips. That's ins, that's outs. So it's about half and half. 11% higher than that, which is probably another 50 trips, 25 in, 25 out. What the gas station is expected to add to the road.
Thank you. No further questions. Thank you, Mr. Westbrook.
Anyone?
Oh, sorry.
Yeah, real quick, Mr. Westbrook. Any questions from the planning commission for Mr. Westbrook?
Was there any study done years ago when Kmart was there? Effects of the traffic?
I do not know. Yeah, I'm not even sure how long, it's 70s. Studies were done at that time of the era, but I do not know.
Anything further? All right, seeing none. Thank you, Mr. Westbrook.
I'd like to call Mr. Sean Sanford. Mr. Sanford, if you could identify your name for the record and spell it for the bill report.
John Sanford.
And Mr. Sanford, what's your professional background?
27 years of real estate experience. Basically the last 22 all commercial,
In what area, what region have you been doing?
primarily start in Summit County.
And when you say real estate experience, can you elaborate a little bit more on that? What kind of work have you done?
Anywhere from mostly retail and office, most part land development, ranging from small, single individual offices to clear up to 65,000 square foot retail,
And have you played the role of developer, broker? What kind of role have you played over the years?
both,
Developer and broker.
yes.
Have you had any involvement with the Meyer project?
Just from the initial onset, yes.
So let me backtrack. What involvement have you had with this site? Have you been engaged by anybody in connection with the site?
Yeah, the property was for sale in the open market. I represented the city, two other colleagues, and helping North Canton to purchase the property as well as have the property listed. Table, interested in the site.
And have you been able to develop any opinions to a reasonable degree of certainty as to the impact of the development on the valuation of the surrounding property?
A Meyer development as well, I mean, similar to a Costco, a Target, Sam's Club, Walmart. Increase the property values around it. There's a lot of retailers that want to be adjacent, you know, to a Meyer, similar use.
And does the inclusion of the gas station as an accessory use to the Meyer have any adverse impact on the valuation of the surrounding property?
No.
Thank you.
Hello, Mr. Sanford.
Hello.
Thank you for joining us this evening. Have you performed any appraisals in regard to the testimony that you're giving?
I'm not certified.
Okay. Have you seen any appraisals
No,
regarding the project?
No.
Can you tell the planning commission what documents you reviewed in preparing for your testimony this evening?
as far documents for what?
Did you review any documents at all in
No.
preparing for your testimony? I'll try and let you finish your answer if you let me finish my question, okay? What documents, if any, have you reviewed in preparing for your testimony this evening? You haven't reviewed a single thing? I have nothing else. Thank you.
Thank you, Mr.
Any questions, of Mr. Sanford from the planning commission? Thank you, sir.
Sorry.
No, you're fine. Thank you, sir.
We call Mr. Charles Gilstein.
Mr. Secretary, do you swear that the testimony you're about to give to this trial will be true?
It will be.
Thank you.
Mr. Snyder, if you can please identify your name for the record and spell it for the court reporter.
Charles G. Snyder, S-N-Y-D-E-R, I go by Q.
And Mr. Snyder, what's your educational background?
Double major, Bachelor of Arts, Miami University, Oxford, Ohio. Subsequent to that, pursued real estate licensure, salesperson and broker. Early on in my career, I decided that I was going to be an appraiser and consultant. And through the then Appraisal Institute, now, or then the American Institute of Real Estate Appraisers, now the Appraisal Institute, received the RM and MAI designations. So state certified in Ohio.
So you are an MAI,
And
and what's the scope of your work in Stark County?
broad. We've had an office in Stark County, maybe 33 years, doing residential, commercial, industrial. There's nothing in my mind from an asset category that we haven't approved.
And have you also done some development work over the years, or appraisal?
I have dabbled in development myself, yes, but I
represent myself as being an appraiser consultant primarily.
And does your practice include testifying on valuation of property in courts or before state agencies?
Yes, in fact, I was in front of the Board of Tax Appeals in Columbus, Ohio this morning.
Have you been repeatedly accepted as an expert on the valuation of real estate before courts and agencies in the state of Ohio?
All jurisdictions, including Supreme Court and state.
Mr. Snyder, are you familiar with the area where the Meyer development is happening? And are you familiar with the project itself?
Only to the extent that I understand it to be a Meyer development, and that there's a question as to the use, initial use for a service station. That's the extent of my knowledge and understanding.
And have you formulated an opinion as to whether the development would have an impact on the value of the surrounding property, of the adjacent property?
As Mr. Sanford clearly, pointed out, compatible uses want to be near like kind. Was cited earlier about fast food wanting to be across from each other and service stations. That's all very, very true. Being adjacent to a Meijer or a big box like Sam's or BJ's or Home Depot or Lowe's, that's a plus. And clearly the beneficiaries of this project are the two existing outlots, being Burger King and McDonald's. Sort of the catbird seat in terms of they should be very pleased.
And does the inclusion of a gas station as an accessory use to the Meyer have any negative impact here?
None of this.
Have you had any involvement with valuation of in situations where there's contamination of the site?
I have.
And do you have any opinion as to whether the development of the site and the cleanup that Meyer is doing here would have an impact on the valuation of the surrounding area?
Would all be a benefit to the surrounding area, clearly. The fact that Meyer is stepping up and either through the NFA and not to sue covenant that's being achieved, but regardless, the fact that the problem, whatever it is, being identified with full disclosure, that's a benefit to all surrounding properties because it comes down to, in contamination terms, what's the PRP, the principally responsible party? It's either the person who did the contamination or the successor buyer who assumes the role of taking care of any remedial costs, whatever they might be. It's pointed out here, this is a voluntary action.
So by Meyer buying the property, it's not just buying the asset, it's also buying the potential liability.
It would be my best wish if I owned a nearby property, some of that financial strength. I have the ability to make sure that my property, if it were to be adjacent, would not, fall to me for any unknown characteristics.
Thank you very much, Mr. Snyder.
Hello, Mr. Snyder. Have you prepared any appraisals in regard to the impact on surrounding properties?
With respect to this case or in general?
This case.
No, I have not been engaged to do any appraisal.
Okay. Can you tell me exactly what specific work you undertook to come to the conclusion that would have zero impact on any surrounding properties?
My experience, which spans company, I am the third generation of an 80-year-old firm. There was a fourth generation, 80 years in Tuscaloosa County, Ohio, 33 years in Stark County, acting second generation myself, acquiring many commercial sites, and knowing how retail users in particular perceive large big box, there's no diminution of value or detriment to any of these. And this is really evidenced by the Meyer development on Fulton, the outlots being developed there and the properties across the street and up the street, which have been acquired in response to or in anticipation of Meyer development.
Okay, other than your general experience over the years, can you tell the planning commission what specific action you took in regard to market analysis of the surrounding areas surrounding Meyer?
Sure, fair question. None whatsoever.
None. I think you testified it would be your best wish if you were one of the adjacent or surrounding property owners. Is it your testimony this evening that the addition of a Myers Supercenter isn't going to impact Acme Fresh Market
In what regard, I'm sorry?
negatively? Is that your testimony, that it won't negatively impact Acme?
My belief, and what I have seen, and we've represented a lot of food stores, including Bueller's, and acquire many of their sites and developing their sites, that people tend to shop for food in clusters, if you will. If there's several food stores, everybody has to be competitive, everybody has to up their game, everybody needs to do the right thing. It's the same thing that's true with fast food and gas stations. Somebody builds a new gas station, and guess what? Somebody else renovates theirs. It's just a free market system. I don't think it has any impact. Acme, because Acme, I represented Acme.
Is that right?
They're great operators. I would suspect that they would fare just fine.
They are indeed. Are you familiar with the Stowe location, sir? The Acme 17 on Kent Road in Stowe?
Yes.
Do you know what, if any, impact the Meyer Supercenter down the road has done to that Acme?
Obviously, I would have.
Do you have any idea what the census data is over the last 20 years in North Canton, how the population has changed? Do you know whether there are fewer or less, or excuse me, fewer or greater number of stomachs now eating in North Canton? What documents did you review, sir, and prepare for your testimony this evening?
I reviewed no documents whatsoever on the entirety of this hire.
Would you agree that you have limited knowledge when it comes to the overall development, that being the big box aspect of this development?
Related specifically to what Meyer intends?
Yes.
Yes, that's a fair statement.
Okay, I have nothing else. Thank you.
Thank you, sir.
Just a few follow-up questions. Just so that the record is clear, are you familiar with the area where the Meyer is going?
It's a lot of properties around,
And
including the buying the site, Speedway up the street, and that Lemon and Oil and ability to develop that. I've actually bought the site, so my breadth of experience on that corridor spans many decades.
And can we talk, I know you've mentioned something about upping the game, basically, that when competition makes you up the game. Can you expand on that a little bit more, what that means, if that causes somebody to invest more in their property, or what does it do what does competition cause you to do to be better, up your game?
Objection, qualifications.
I don't mean to sound flip, it does, because I don't intend it that way, but forget the name of the economist said that excess profits breed ruinous competition. That's the case. If you're a standalone, you tend to invite competition. We do a lot of hotel is, running at above 66% occupancy. Somebody else is going to come in and build, and then somebody else may come in. There's only so many bites of the apple, if you will, and that piece of pie is only so big. And at some point, everybody has to up their game, response to your question, to get their fair share of what that pie.
And could upping the game mean investing in the site to improve the site, make it more attractive?
Not the site per se, but the internal nature of the property, the shopping experience that we all hear about. That's clearly a potential for anybody in the business.
And in terms of the impact on the real estate itself, without regard to what position Acme may take, the impact on its sales as a site, as as a real estate owner, not as an operator, does the development across the street have any negative impact on the site itself?
I believe it's just the opposite. I think the opportunity across the street is far better with a Meyer across the street. Clearly, even from an operational Kmart, but without any hesitation, Kmart is closed.
And if I'm going beyond what you know, let me know, but do you know if typically retailers own the site in the same entity that has the operator, or there's different ownership usually between the owner of the site and the operator?
There's as many ways as you'd like to mix it up in the world of today for a variety of reasons.
And there are tax advantages to having a different entity own the site versus the operator sometimes.
Clearly, one of the biggest ones would be the nature of a leasehold interest, where a gas station or a bank or a fast food might be on a leased site instead of a fee simple owned site. That would be an example of different entities owning different components of it.
Thank you.
My pleasure.
Question, just one quick follow-up, please.
Mr. Snyder, you said you think, right? You think it wouldn't have an impact or an adverse impact on Acme. You think it wouldn't have an adverse impact on the surrounding properties, right?
Sorry.
No,
I didn't mean to interrupt.
no, that's okay. That's fine. But just so that I'm clear, as far as actual analytics, as far as actually analyzing the economies in the surrounding properties, looking at the data, looking at the square footage, how it's leased, the revenues, that sort of thing. You haven't done any work, as I understand it, in terms of actually analyzing those properties. Is that fair?
That's fair.
Okay. I have nothing else. Thank you.
To the board, may I recuse myself to go to another meeting this evening?
Hey, we're done.
We're done?
Yeah, thank you very much.
My pleasure. Thank you all.
Oh, sorry.
Mr. Snyder, just 1 second. Are there any questions from the planning commission for Mr. Snyder?
My apologies.
Okay, no. All right, you're good. Mr. Snyder, thank you very much.
Would like to call Mr. Rob Grant. Mr. Graham, you've heard me say this repeatedly. If you could please identify yourself for the court reporter telling everything.
Yes, Robert Graham, city engineer, for the city of North Canton, ROBERTGRAHAM.
And Mr. Graham, how long have you been the city engineer in the city of North Canton?
5 years.
And what does the role of the city engineer involve?
Quite a bit, actually. I guess my major role is overseeing capital improvement projects in the city, whether it be water lines, sewer lines, roadway improvements, repavings, reconstructions, widenings, primary role. And basically from cradle to grave, identifying the problem with our department heads, to finding the financing, working with council, getting grants, and seeing it right through to construction, and answering questions years later, what we did.
And do you have any role in connection with private development?
Very little, other than just as part of the administrative review of site plans that are submitted.
So let's walk through that administrative review. What is your role typically in the administrative review of development like the Meyer?
And we take a look at ingress, egress, as part of the traffic study, and complicated ones, we would actually get a second opinion from a traffic engineer. Would look at the utility demands, would look at the infrastructure of our streets, and would handle it. The big one, of course, is drainage. How do we handle drainage? Standards, water quantity is Stark County regional plans. And water quality is Stark County Soil and Water Conservation District.
And so walk me through what that means. So when you say, well, let's talk through traffic review, that would fall into your department?
Yes, yes.
So how would that happen? Would the property owner or the developer come up with a traffic report? How would it work? Walk us through
Right,
the
we would look at the proposal. If it's a small doctor's office, it's only seeing a few patients a week, that really wouldn't justify a traffic impact study. But something like a big box store absolutely would. So that's one of the requirements. When we would have our initial meetings, in fact, with the developer, things we would be looking for, and that would be one.
And what happens if you're not satisfied with the traffic impact study that's submitted by the developer?
We would offer comments if we weren't satisfied with the data or how they went about doing it. We would ask them to take a look and rerun their calculations.
Have there been any situations where you did that?
We have done that. So I can elaborate on
Sure,
it? Yeah.
absolutely.
We had an interested party a number of years ago, a fast food restaurant, that wanted to look at the former post office site in the city. And we asked them to do some traffic impact study, and it justified the need for a turn lane, which would have been quite expensive, and construct that, and look somewhere else for a site.
So you held them to the standards that you applied to everything?
Yes.
And is there any reason why you would do that with respect to this project?
I would look at everything, same. Look out for the safety and welfare of the citizens. Yes, driving through town.
Thank you very much.
Good evening, Mr. Graham. You're the city engineer. Do you have an engineering degree, I assume?
Yes, I did. I did not go through my qualifications, but I can.
No, that's okay. I was just curious. Mechanical, civil, nuclear, what type of engineer are
I
you?
had a bachelor's degree in civil engineering from State University, completed my master's degree in civil engineering, or degree in course requirements from University of Akron, and I'm also a registered professional engineer for the state of Ohio.
I thought I heard you testify, I know I heard you testify, I wrote it down in quotes. Turn lanes are quite expensive. Or in the case that you were referring to, the turn lane would be quite expensive.
Yes.
Okay, do you know that the traffic study that has been commissioned already and it was submitted earlier as an exhibit? Have you seen that traffic study?
Yes, sir.
Okay. Do you have any idea what the cost of that would be, the public improvements that are outlined as far as conclusions and recommendations?
I have not I do not know off the top of my head what it would be. I mean, I could venture a guess based on my experience, but
Go for it.
$1 million.
$1 million?
Somewhere in that. That's everything. That's Stratavon, that's traffic signal.
All the items that are listed, 1 through 4? Okay. Do you know, sir, who would bear the cost of that?
I do not. In my role, I just lay out what I would recommend needs done and contribute to negotiations.
Have you seen a copy of the purchase agreement between Meyer and the city?
I have not.
Have you seen any specific plans that deal with any of the items 1 through 4, and the conclusions that are set forth in the traffic study?
Yes, I've seen a preliminary signal layout provided by Myers engineer Wolpert.
Okay.
I have seen a preliminary layout for an improved Stratavon Street.
Okay.
And I've seen the various driveway improvements that they've mentioned.
Okay. And is that part of the application this evening? You know, has that been submitted to planning commission in support of the conditional use application?
I will have to do some digging to see. Don't know the answer to that.
You say when it is, I believe I heard you say, when it's complicated, typically the city then goes to an outside expert to do some additional analysis.
I will. I think in my field, it's very, I kind of like the analogy of physicians. I'm kind of a general practitioner. But something like traffic engineering, maybe cardiology.
Fair enough. And in this case, you deemed it complicated enough that in fact the city did retain an outside expert, right?
We have, and I've also talked with one other traffic engineer.
So do you agree that it's a complicated project?
Absolutely.
Have you reviewed by chance, as the city engineer, the phase 2 environmental studies that were performed with regard to
I
the
have
two
not
portions?
seen.
Never.
Nope.
Can you tell the planning commission what documents you reviewed in preparing for your testimony this evening?
Yes, I've seen additional what I mentioned, the preliminary roadway layouts, preliminary site plans, preliminary drainage plans.
Okay, do you know whether or not there were any conditions that were attached to the general development plan that was approved on
Yeah,
August
here
3?
at the last meeting, I believe 5 were part of the minutes.
Okay, and do you know how many of those 5 have been satisfied as we sit here today, Mr. Graham?
None have been formally submitted as of right now.
So 0 out of 5 have been satisfied, is that fair?
As of this exact moment, that would be my guess, but maybe they have been submitted, I haven't seen them.
Okay. Thank you.
Mr. Graham, you've testified that part of your role also involves oversight of the city's capital projects, correct? When the city undertakes a capital project, who approves the ultimate expenditure of funds on that project?
The ultimate expenditure of the funds rests with the city council.
And that's the elected representatives of the residents of the city of North Canton, correct? And they would also have to appropriate the funds for that project, correct?
Can't do anything with up to $50,000 without their.
Without the legislative appropriation of the funds, nothing can happen. In terms of the traffic approvals that happen in the city, can you talk us through the timeline, when typically that happens, and what stage of the process?
Pretty much kind of early to midway through. I mean, we'll ask for it early, just in case a proposed developer sees something that's maybe cost prohibitive and allows him to go to another site. Last thing we want to do is see a developer spend a lot of money on engineering and then not follow through. So we try to meet with them very early and then let them know these are things we're looking for, so that they can proceed without a huge expenditure.
But does that usually happen before review by the planning commission or after review by the planning?
I've seen it both ways. Typically, I guess we'd like to see it early in case there's a red flag, and then that way their application to the planning commission can have that to avoid condition of approval. But we've also done it where we issue conditions.
And that's why your code talks in terms of the conditional use will comply, meaning that that part of the review process happens subsequent to the planning commission's approval, right? Thank you, Brian. Chris, any further questions?
No, sir. Thank you.
The planning commission.
Any questions from the planning commission for Mr. Graham? Seeing none, thank you.
We call Mr. Martin Van Gundy to the
You want me at the podium?
item at the discretion of the chair.
Yeah, please go to the podium. Yes, sir.
I think the planning commission is sick of me asking the witnesses to identify, so you know the draft, if you could identify your name and spell it for the record.
Mark Van Gundy. And
And Mr. Van Gundy, what's your position, what's your professional position?
serve as the city's director of events and development services. Building commission,
And how long have you served in that capacity?
approximately 3 years, 10 months.
What did you do before that?
Consulting company. I currently
Mr. Van Gundy, will you please speak up?
Yes, sir.
Thank you, sir.
And Mr. Van Gundy, what's your education background?
have an associate's degree in public safety, general studies, a bachelor's degree in psychology, and approximately 35 certifications through the International Code Council, one of which being the Master Code Professional, licensed with the Board of Building Standards, and it's a building official.
And is the licensure with the state, with the Board of Building Standards, vary with the continuing education requirements?
All of my certifications.
And do you follow through with all your continuing education requirements? Mr. Van Gundy, were you involved, you heard the testimony of Mr. Suter about the zoning amendment process that happened in 2018 and all of that. Were you involved in that process?
I was on the latter part of that started a number of years, as I understand.
And my only question really is, are you aware of that process involved public input?
I am.
What public input did that process involve?
Well, before it formally began the legislative track, there was invitations sent out to each of the property owners along Main Street and invited in for a workshop where this was discussed. We received input and incorporated that input before sending it to City Council, then reverted to Planning Commission, and Planning Commission made some recommendations on changes. Sent it back to the City Council where it received its public hearing.
And was all of that in meetings that were open to the public?
They were.
Properly advertised meetings?
They were.
You've heard about the latest amendment about the gas station addition of the conditional use, accessory conditional use. Did that also go through the regular process for adoption of zoning amendments?
It did. Same process, started in City Council, referred to Planning Commission, sent back to City Council.
There was a public hearing that was open to anybody to come and speak.
There was actually with both boards, there was a public hearing. Planning Commission.
And the council adopted that in July.
That sounds about right. My feed there is cluttered with all my notes.
And the time for any referendum has expired on that.
I believe so.
Can you walk us through the general approval process that happens with a conditional use in the city of North Canton? How do you handle that?
So the ordinance recommends a pre-application meeting. The result of that, strongly encourage that pre-application meeting where we meet with the applicant and we invite all the department heads in the city to talk about the project. Level of information needed essentially for that. The next process where they make application, review that application. Once it's complete, coordinate with the planning commission meeting. Do a development review as part of that. Might add with the development review, do incorporate the preliminary and a final. And the second part of that is the conditional.
And what happens with respect, how does the administrative review process, once you're done with the planning commission, how does the administrative review for the project?
Typically, what we see is the complete review for the zoning, anything that was required in planning commission is incorporated into the plans along with the building review, which is required by the state. We do both of the reviews.
And do you ensure as part of that review process that all requirements are met? I know you've made a recommendation with respect to the general development plan when it went before the planning commission. Do you have any recommendation for the planning commission with respect to the conditional use?
I do. Staff finds that the application does comply with the North Canton ordinance, particularly 1145-2 and 1145-3. With that, making a recommendation for approval with 5 conditions. I have those 5 conditions.
Is there a way we can?
Yeah. Condition number 1, provide a final approval on the traffic impact study from the city engineer. Incorporate all conditions and recommendations from the final traffic study as approved by the city engineer. Condition number 2, stormwater quality / quantity plans to be submitted for review and approval by Stark Soil and Water prior to any site work. Condition number 3, provide a recorded and fully executed Mylar copy of the recorded plat reflecting the minimum 5-acre parcel for the conditional use permit as per ordinance 24-2022. Condition number 4, provide a wetland delineation study prior to the issuance of building permits and incorporate any required mitigation. Condition number 5. Excuse me, 4 conditions.
And can you explain the Mylar condition, what you mean by that?
The Mylar is a process in which the plat is drafted, prepared with legal language, and signed by appropriate representatives, and legally documents the property.
So you've heard the discussion, I think when Mr. Suter testified, how the, as part of the development process, you go through the site acquisition, go through the zoning approvals, but then there's the consolidation of the lot. Is that what this Mylar is intended to achieve?
Essentially.
Then, once it's approved by the city, is there any further action at the county level with the lot consolidation?
Once it's approved, it gets recorded at the county auditor's office. They also have a review process.
So one of the conditions that you're asking the planning commission to require for this project is that the lot consolidation into one parcel thus take place before the building permits are issued?
Yes.
Thank you. I have no further questions.
Good evening, Mr. Van Gundy. It's getting late, so I'll try not to go on longer than is necessary. The 5 conditions that you mentioned, are there 4 or are there 5?
There's 4.
Okay, I had 5. I had 5 conditions written down. I'll go through my 5 and tell me if you've written them, okay? Approval of a traffic impact study from the city engineer. Yes?
That's not all of the condition.
No, that's first condition. That's,
Oh, I see where you got 5. So 1 has 2 sentences, 2 parts to them.
well, let's just walk through them. Is that all right? So approval of a traffic impact study from the city engineer, that's one condition. Hey, that's a condition, is it not?
That's not how. Condition 1 has 2 parts.
Okay, go ahead. Why don't you tell me then?
Okay, second part of condition 1 was incorporate all conditions and recommendations from the final traffic study approved by the city engineer.
I agree with that. Okay, has that happened?
Not to my knowledge.
Okay, do you have any sense or any timeline as to when that will happen, if at all?
That's out of my scope. I would coordinate with the city engineer on that, so
Can you-
I do not have a time.
Do you know, is it more or less than a year?
Oh, I would say it's well,
Well within a year? Can you say it's well within 6 months?
I would know.
Okay, so it's possible it's beyond 6 months. Okay. Stormwater quality quantity plans, review and approval by Stark Soil and Water. Is that one of the conditions you have written down?
That is,
Okay. Has that happened yet? Okay, and this is for the principal use, the general development plan for the principal use, right? These conditions are attached to that.
there are similar conditions.
We're going through those right now, though. That's my point. I'm saying, to be specific, these actually apply to the general development plan that was approved on August 3rd.
Right, those are 5 separate conditions.
And we're walking through those together right now. You agree?
Mr. Van Gundy, for clarity purposes, the conditions that you mentioned earlier, are those for the general development plan that we discussed on August 3rd? Or are those for tonight's conditional use permit as we're discussing it this evening?
Some of these are duplicated from the development review. These conditions that are recommended, 4 conditions.
Well, I apparently wasn't clear enough, so forgive me. I'm asking you now specifically with respect to the general development. Okay? That was approved on August 3rd. You remember that? There were 5 conditions that were attached to it, correct? Okay. One of them was the impact study that we talked about, the track study, and including the recommendations, right? That's one.
Right.
Not done yet, correct? And it could take as much as 6 months, as far as you know. You're not sure.
Objection.
Okay. Stormwater quantity, quality and quantity plans, review and approval by the Stark County Soil and Water. That was the second condition. Attached to the general development plan, right? Okay. Has that condition been satisfied? Okay. Do you have any sense of when that condition will be satisfied?
As far as time, no, but it will be required before we issue.
Okay. Could it take 6 months? Okay. Do you have any sense of the timeline at all? So as far as you know, it could be a year. You don't know.
I would expect.
Okay, I don't want you to speculate. The recorded plat, let's set that one aside, but that's one of the conditions, right? Okay, and as we stand here this evening, that condition has not yet been satisfied. All right, how about the wetland delineation study? That was one of the conditions that was attached to the approval of the general development plan, correct? Has that condition been satisfied? Do you have any sense of when that condition might be satisfied? Do you know who is responsible for approving the wetland delineation study?
Ultimately, we do work with Stark Soil and Water and
What about the Army Corps of Engineers?
it depends, but if they have jurisdiction.
Do you know whether the Army Corps of Engineers has jurisdiction here?
I don't.
Do you have any sense of the timeline for when that will happen?
Again, before the issuance of the permits.
Do you know whether or not there's actually been a study done at this point?
I don't know if it's completed, but I believe there was one.
Have you seen a copy of the purchase agreement between the city and Meyer?
Objection.
Conditional use permit for the gas station, that's what we're here about this evening. That was the 5th condition that was attached to the general development plan. Completion of the voluntary action plan. You guys didn't think it was appropriate to make that a condition of approval of the general development plan?
There is provisions in the ordinance that require.
What, can you give me an idea of where within the zoning code you're referring to, what the codified ordinances?
Yeah, it's not the zoning code, it's 1305 2, I believe. I can't remember
Okay, so is it your testimony this evening that the gold standard has to be attained in terms of securing a covenant not to sue on that property?
Objection, the code speaks for itself and characterization.
You can test, you can answer that.
That's outside.
So you don't have an answer to that one way or another, is that fair? So you don't know whether or not cleaning up the site in a manner that would secure a covenant not to sue, you can't tell the planning commission whether or not that is a condition to actually approving the general development plan? Or are you saying it is?
That's a condition of permanence.
Should it be a condition to approving the general development plan? Okay. What about a no further action letter?
Objection, relevance.
Same answer. I don't, it's not necessary, but other ordinance provisions.
How about compliance with the voluntary action plan?
I would have to research in that. My understanding is voluntary.
Do you know who's gonna bear the burden of the remediation of that property? I have nothing else. Thank you.
Thank you. No, unless the commission has any questions.
I have one question for you, Mr. Van Gundy. Typically, when you issue these conditional use permits, are the conditions that you place upon the issuance, are they satisfied when the initial conditional use permit is issued?
Just to clarify, you're asking if the conditions from the development review are set?
When you recommend approval either for a general development review or for a conditional use permit, in your experience, the conditions that you place upon your recommendations, are those often satisfied as of the date that you make your recommendation? In your experience, do you typically work with the applicants in order to ensure that satisfaction of those requirements are met? In the event that they are not met, what happens?
Well, one of two things would happen. If it went beyond the 12 months for the conditional use, the conditional use would require. Or if they apply for building permit, this building permit.
In the event the conditional use permit would expire, what would happen then? They would have to go through the application process again. Is that a fair statement? Thank you, sir. Nothing further from me. Any questions from the planning commission?
The city, Mr. Van Gundy, the city is the current owner of the property, correct?
Yes.
Including the outlot. The one such that's going to be dedicated for the gas station. So is the city going through the lot consolidation, or was it Meyer after purchase?
I don't know. The plats are handled through the city engineer's office, so I get them and review them once they're complete and review for compliance with the zoning code, but ultimately it's the city engineer that approves the administrative.
So if there is no lot consolidation, I guess is the timing, that's why I'm asking the question. We're talking about the conditional use without a lot consolidation. Is that where we are now?
Can I attempt to clarify your question?
Sure.
One of the conditions of the conditional use permit is the fact that you would receive a consolidated plat prior to issuing any sort of permit. Is that correct? So in the event that they are not consolidated, would you issue the permit? Thank you.
So that's my question for whether the city is doing the lot consolidation or Meyer is, because Meyer would have to purchase the property in order to do that, correct?
Yes. I think that'd be a question. Do we have somebody from Meyer that could answer that question?
The typical process is the purchaser after closing would, and that's why it never happens in the zoning phase, never happens in the, this is the unique case where you have the city actually owning the property.
You should be sworn as a witness if you're gonna testify.
I'll swear. The typical process.
You should,
Okay, that's fine.
in all sincerity.
In all sincerity, this is we'll have somebody testify to that issue. We'll have somebody testify. The typical process is usually when you buy property, not about this property. The typical
I
process.
understand the process.
No, my objection on the record.
Any further questions from Mr. Van Gundy?
I have one unless, as you.
I have more based on the follow-up question. These conditions of approval are conditions, correct? So by definition, if they were met before the approval, they would not be conditions on the approval, correct? And that's why typical they happen after the approval. most of, all these conditions actually require action by Meyer, correct?
Yes.
And Meyer gets to dictate the speed at which they get those things done and submit them to the city, correct? So for all you know, Meyer could be already working on those things and they could be submitted next week if they so choose, correct? So that is not something that the city would slow down, that is something that is dictated by Meyer. And you've mentioned that there is a date at which the conditional use approval would expire, correct? Do you know what that is?
12 months from the date it was approved.
And is there similarly a date on the expiration of the general development?
There is.
And what's that?
12 months.
So the incentive is already built in for the developer to have everything finished within the timeline to make sure that there is no expiration of the conditional use in the general development. And if they were to request any extension, that would be at the discretion of the planning commission or the council.
I believe it's Mike.
Thank you. And if we may, after this, we can take a 5-minute break. We would appreciate just a restroom break.
Sir. Wait.
May it please the planning commission, ladies and gentlemen, I'll be brief. We're conflating conditions, okay? There were 5 conditions that were attached to the approval of the general development plan on August 3rd, is that right? Okay. Whatever conditions you may attach as conditions to the conditional use approval this evening, if in fact that happens, that's a different set of conditions. They may be the same, they may be different, but they're two different approval processes. Right. Okay. As I understood your testimony, none of the conditions that were attached to the general development plan have been approved as we stand here this evening, correct? Okay. And the conditional use that we're here about this evening is an accessory use. Right? It's accessory to that principal use, the principal use being the general development plan that was approved on August 3rd. Right? So it's conceivable that you could approve a conditional use permit this evening, and then lo and behold, 5, 6, 7 months from now, you've not satisfied the 5 conditions that are attached to the principal use. Isn't that right?
For the accessory use?
Yeah, I mean, it's possible that you could approve this evening a conditional use permit, right? But then you could have a development plan that doesn't, ultimately, those conditions aren't satisfied.
Not necessarily.
But it's possible, right? How is that not possible?
The
Explain it to me.
ordinance requires accessory use approval after. So the approvals are in place. There's still other ordinances.
But I guess that's my question, it begs the question, why would you approve a conditional use if you don't have any assurance that the general development plan conditions are gonna be satisfied? Why would you do that?
It's a project and a plan. The plans are a plan to build a project.
Seems premature.
That's how all projects start.
Okay, well, I guess it's good to know the planning commission is informed and understands that the conditions for the general development plan have not been approved. Those are for the primary or principal use. And notwithstanding that, the applicant's seeking approval of a conditional use application for an accessory use to that, so.
Can we swear him in?
I was gonna
please?
say,
I have nothing further, so thank you.
any further questions for Mr. Van Gundy? Seeing none, I will grant that 5-minute recess for restroom. Please be back at 8:15. Everybody, let's come back from break. Report reporter asked me to place on the record that the reason that the break lasted longer than 5 minutes was the line for the men's restroom, not the women's. So we'll put that on the record. And at this point, Majid, please continue.
I think we will rest at this point. Obviously, we'd like to do closing arguments.
Is there anybody else present who would like to testify, be sworn in and testify on this matter? All right, seeing none. Attorney Swing, I believe you reserve time, so feel free to closing statements.
Well, may it please the planning commission, I'm not gonna get hung up too badly about it, but I think it's the applicant that bears the burden of proof, so I would submit respectfully that the applicant ought to go forward with opening or closing arguments first.
Thank you, and I'll reserve some time for rebuttal. So, thank you very much. You've borne with us quite a bit this evening. I truly want to thank the planning commission for the patience that you've put through this process. I know this has been a long evening, and I know it's the second evening that you've gone through this. And I want to thank you for all the consideration. We asked the planning commission to approve the conditional use with the conditions outlined by the director of permits, and to also make conclusions of fact with respect to the determination for the conditional use. Now, I'd like to make a couple of points. We heard a lot of testimony tonight. You heard some testimony even the night before. And I think it's important to I just want to highlight a number of issues for the planning commission. We've heard a lot of discussion about the separate parcels. And I was reminded during the break that Mr. Suter did specifically testify on this issue. So you heard from a sworn witness on the issue of the parcels and the typical way that this happens. If you think of any development, the way that a development happened is there are multiple parcels that a developer would come in, would compile the different parcel from the different owners. But nobody would close on the purchase of the property until they have the zoning approvals in place. And you cannot consolidate the lots because you have to have unitary ownership to consolidate the parcels. To do a parcel consolidation, you have to have unitary ownership. So the typical process is the consolidation of the parcel is a condition of the approval. And then that would mean that the property owner would buy the property, would have in this case, Meyer, whoever, would have to buy the property before the consolidation happens, because you have to have unitary ownership for consolidation, and then the consolidation happens and you go further with the permits. But if the consolidation doesn't happen, one of the conditions of the permit are not met. So it doesn't go forward. The protection is already built in the system through the condition. That's why the code allows you to place conditions. That's the very purpose of the conditions. The code, if you look to the requirements of it, it specifically says there can be an approval outright. There could be an approval with conditions. So the code contemplates that it's sometimes, and I would submit to say that it's most often than not, that there would be conditions that are not met at the time of the approval. Those are placed as conditions on the approval and they're met after. In terms of the timeline here, I think we've made much ado about nothing, because the timeline here is Meyer having the duty to meet those timelines. And Meyer is incentivized, if it wants its development, to get the work that needs to be done as quickly as it's done, and so that it can effectuate those conditions, meet those conditions, and move them on. So the burden is on the applicant to have those conditions met and to do it as expeditiously as they need to do them for their purposes for that project. And I have every reason to believe that Meyer would proceed with the most expeditious way here to get all those conditions met, provided, thankfully, if we get the approval in time. One point that I'd like to highlight, and I think it's just been, sitting almost in a deja vu hearing where it seems that we're fighting a fight that is not before the planning commission. We're fighting a fight about the proper zoning for this property. That fight is gone, it's finished. It's been through the amendment that was referenced on the screen, allowing gas stations as an accessory conditional use. It has happened. You've heard from Mr. Van Gundy that there was a public process for that. There was a public hearing. There was the entire process happened. There was councilmatic action. And the council voted and rezoned the property and did the amendment to allow the gas stations as a conditional use. So that is entirely not a proper question before this court, before this planning commission. It feels like a court before this planning commission. That question has been resolved. The question for the planning commission is the grant of the conditional use under the zoning code, not what the proper zoning of the property is. It's too late for that discussion to happen tonight. We've heard the discussion about traffic, and I think you've heard from Mr. Kevin Westbrooks about the minimal impact here and how there is no adverse impact on the traffic. It is critical to understand we're talking about an out parcel. An out parcel, there's a whole laundry list of uses that are permitted as a matter of right on that out parcel. Each one of those, as Mr. Westbrooks testified, brings traffic. So we're trying to blow up this idea that a gas station that is an accessory use to a principal use that brings marginally additional traffic is somehow going to be the issue here. When, again, when you're thinking of the possible uses here and the uses that are permitted as a matter of right to be there, traffic is really a non-issue and it's much ado about nothing. Meyer submitted a traffic impact study. Meyer's traffic study suggests improvements that would happen to the site. That means that Meyer intends to do those improvements. That happens as part of the project. It's not, Meyer would have been, if they didn't want to do those improvements, they wouldn't have submitted a traffic impact study to the city showing the improvements that would be associated with that project. This is the developer's traffic impact study that's been submitted to the city. All this discussion about the taxpayers bearing the burden of the work. What is the role of the planning commission in this? It is completely improper to bring that as a question before the planning commission as to who bears the cost of those improvements. That is not a condition, that is not a criterion under which you consider a conditional use. And even if those costs were to be borne by the city as opposed to by the developer. Again, you've heard from testimony, and I don't think you need any testimony about this. You know this very well. This is a governmental body with a legislative, the city of North Canton has a legislature. And the appropriation and expenditure of funds has to be approved by the people's elected representatives, by the city council. So if the city were to bear those costs, which they're not, but if they were, they would be done by the, approved by the city council, but entirely an improper question for the, to somehow deny a conditional use because any improvements would be borne by the city. That gets negotiated between the city and the developer. They will work out whatever is appropriate between them. That is not a question for zoning. You've heard from Jim Smith, who's working on the environmental remediation and the construction of the site. This is not some hypothetical person coming in giving an opinion off the street. This is the actual person working on the voluntary action program, getting the approvals, getting the no further action letter, getting the covenant not to sue. But again, we've heard all this testimony about construction can't begin until after the covenant not to sue. The covenant not to sue is a liability protection to Meyer. Covenant not to sue has nothing to do with the conditional use approval. If Meyer makes the decision to take the risk, I think you've heard the testimony that came out that when they buy the liability with the asset. They don't just buy the asset, they buy the liability that comes with the asset. So if they choose to take that risk and do the construction, that is their decision. That is their risk. They would have to do their own risk assessment and make that decision. They go through the voluntary action program to get the liability protection from the state. And they would be developing the property. But critically, however, you've heard from real estate appraisers, highly qualified real estate appraiser, who's done a tremendous amount of work in this community, who's very familiar with the site, who told you that there is a positive impact from this development on the surrounding property, the valuation. You heard from a broker who was involved with this parcel and is very familiar again with real estate valuation that told you there will be a positive impact. There is no requirement that an expert report be prepared before a planning commission. That's not there are some courts that have requirements like that. That's not a requirement here. You're able to look that witness in the eye and determine their credibility. You're able to hear what they said and know whether their testimony is credible and worth giving consideration. And I submit that you've heard from some very credible witnesses tonight, and we ask you to give them the due consideration that they deserve for their testimony. So with that, I think you've heard from all of them. I will wrap it up instead. I'm a lawyer, I can talk forever, so you need to shut me out. I want to thank you very much for your patience with us. We ask that you grant the conditional use permit, and obviously we think that those conditions make a ton of sense, and we ask that you also be conclusion of fact with the bond. Thank you.
Okay, please, the planning commission, the burden is the same as it was last time that we met back on August 3rd. That's the issue that is before the planning commission this evening. The question is whether or not the conditional use application and your decision that you're going to render this evening is based upon and supported by a preponderance of the substantial, reliable, and probative evidence on the whole record. That's the issue. That's the only issue before the planning commission. And I would submit to you respectfully that, frankly, the testimony that was brought forward this evening raises more questions than it answers. It raises more questions. None of these witnesses were prepared. None of these witnesses had reviewed any documents in preparing for their testimony. None of these witnesses had done the hard work of rolling up their sleeves and actually analyzing what the impact's going to be. These were conclusory statements paid by paid witnesses to try and advance the conditional use application this evening. The applicant, and by the way, I'm not clear, and I mean no disrespect, Mr. Makhlouf. Who do you represent this evening?
I'm not here to answer questions. I think I identified it on the record when we started.
Okay, well, you're here on behalf of the city, right? And I thought the city, is that right?
I'm not going to engage in this.
I thought the city was a neutral. I thought the city was a neutral in this. So Mr. Makhlouf is not even here on behalf of the applicant. He's here on behalf of the city. In the beginning, okay, they've done nothing more this evening to fill up the cup with evidence. It's just a bunch of conclusory statements made by paid experts who've done no homework. But the unlawful rezoning that took place to begin with, they keep cloaking it in this public hearing. There was no adjudication hearing with respect to the amendment to the zoning regulations that allowed for a conditionally permitted use for a gas station as an accessory use. There were no 5 minutes of public speak. Is that what it was? Maybe at that. So there was no adjudication hearing. And you heard the testimony that it was narrowly amended only to address the specific lot in question here for Meyer. Didn't affect anywhere else, in any of those other 4 districts. And by the way, you know, the general development plan, which is the principal use here, right? Again, we're here this evening on on an accessory use, and we're still putting the cart before the horse. The principal use actually has been appealed. The development plan that was approved on August 3rd has been appealed. Okay, and what your zoning code says is that while that's on appeal, any further action with regard to it is stayed. And I would submit to you respectfully, you don't even have jurisdiction this evening to grant the conditional use, because I think any further action with regard to the development is stayed. It's interesting to me, again, just another example of cart before the horse, right? The general development plan was approved before the traffic study was even considered. There are no specific plans for the public improvements for the traffic. There are no specific plans in place that I've heard or any evidence that's been brought forward with regard to the environmental remediation or abatement that has to occur. This could go on for some period of time, and I'm just asking the Planning Commission this evening, why would you approve the conditional use application at this stage of the proceeding? It's premature. Mr. Magluf mentioned separate parcels and needing unitary ownership. I think, Mr. Mahalson, I think you asked. The city owns both those parcels, I believe is what the testimony is.
What I asked.
So there is unity of ownership as we sit here today. The city could consolidate those parcels. There's nothing preventing it from doing that. Okay? But right now, they're on 2 separate lots. And according to your own zoning code, you can't have an accessory use to a principal use on 2 different lots. It's in black and white. It's in your zoning code. You know, sort of the umbrella over all this is, it defeats the spirit and the intent of what the zoning code was intended to do. Section 1136, with respect to the development of this very key and very valuable strip in the city of North Canton. It doesn't satisfy any of those goals that were set forth in 1136-01 that we went through. And it doesn't distinguish. It doesn't distinguish between North Gateway, South Gateway. The only distinguishing characteristic is that you guys, or I shouldn't say you guys, City Council passed a very tailored and very narrow amendment to the zoning code to allow this to happen for Meyer. Still doesn't comply with 1145-02. We've already made the record on that. We made it on August 3rd. I'm not going to rehash that. It's been a long evening. I'd submit to you respectfully that the general development plan doesn't comply with 1175 or 1175-05 or 1175-07 of the zoning code. And none of those conditions have been satisfied. And as long as those conditions have not been satisfied, you don't have a principal use that's been properly approved, and you can't have an accessory to something that doesn't exist. What Myers wants to do and on what timeline and who bears the burden, the truth of the matter is the general public doesn't know because the purchase agreement has not been made available to the general public. I've asked for it repeatedly. I can't get a copy of it. I'm being stonewalled on it. Is there a commitment to locate a Myers at this location? Seems to me the testimony is maybe. It either is or it isn't. Is it committed to locating it there? If it is committed to locating it there, I'm entitled to a copy of the purchase agreement. So are you. So is everybody in the public. We should all know what the actual timelines are. We should all know what the actual contingencies are and when those contingencies have to be satisfied and what those timelines look like. In the absence of that, it's very difficult to tell. We heard testimony that some of the environmental stuff alone could take until November of 2023. So why would this planning commission feel the need this evening to be pressured or to be hurried into approving something where there are so many outstanding conditions to be satisfied? It's been a long evening. I'm not going to take any more of your time. I would only ask, I'm going to ask that there be one more item that is admitted into the record. Okay, this is the phase 2 environmental for 1447 North Main Street. This is the gas station parcel. I've looked at this exhibit 14. I'm going to hand it to the Madam Stenographer over here. Thank you. While the planning commission has discretion, I would submit to the planning commission this evening that the standard hasn't been satisfied for approving a conditional use permit, and therefore it ought to be rejected. Thank you.
Thank you very much. Just very quick point. Obviously, I identified myself when I started. And it is, the procedure, in North Canton always is the city. You hear from the city, you hear from the, director of permits. He normally speaks after the applicants and provides you, with his testimony. The city has every right, to submit testimony before the planning commission. The city doesn't have the right to tell the planning commission what to do. We come before you like any other party and make the city's position and provide the testimony to you, but at the end of the day, that is the decision of the planning commission. And there's case law in Ohio where there are cities who appeal. There's a case from Willoughby Hills where the Board of Zoning Appeals went against the city, and the city appealed its own Board of Zoning Appeals to court, and the court said that is wrong. So cities come before their bodies and present testimony. Sometimes the cases go for the city, sometimes the cities go against the city. The city can provide testimony here, and two, the property is also owned by the city's community improvement corporation. So I think the city has every right to be before the planning commission, but obviously we fully are cognizant that the decision of the planning commission is the decision of the planning commission, not the decision. We don't get to tell you what to do. We make the case to you, and the decision ultimately is in your hands. The question about the stay and the planning commission having no jurisdiction over the conditional use. I think if you read that code very clearly, it talks about in furtherance of the general development plan. This is not in furtherance of the general development plan. There's two separate proceedings: the conditional use proceeding and the general development plan proceeding. The commission already voted on the general development plan. This is not something, this is not an action based upon the general development plan. This is the conditional use itself. What he's talking about is, quite frankly, a provision in the code that, if you want to look to the intent of that provision, the reason it exists is because the appeals board in North Canton consists of both the Board of Zoning Appeals and the Board of Building Appeals. So you have, it hears appeals both of building violations and also of zoning limitations. And that is a provision that is very typical in all zoning codes, which is if you have a citation on the property, let's say there was a code violation, and that property owner appeals to the Board of Building and Zoning Appeals, or wherever the name of the board in that jurisdiction is, it prevents any further proceedings. What they're talking about is they don't want while there's a pendency of an appeal within the city, they don't want the city to be able to enforce that citation against the property owner, be it go to court and file the complaint to demolish the property if there is a building code violation of that extent. That is what that provision is intended there for, not for the kind of approvals that we're talking about here. And that's why it's proceedings. It's talking about court actions, actual proceedings that would be stayed in furtherance of the action, in furtherance of that citation. You can't go ahead and demolish the property or take action. And even the exception to that to that provision in the code is very clear about life and safety, which shows you that it's really about building code violations, not about the kinds of approvals that we're talking about here. But for the sake of argument, let's say it's even beyond. Those are two separate proceedings. The conditional use is separate from the general development plan. And this is not action in furtherance of the general development plan. We're not seeking a building permit based on the general development plan. That arguably, if Mr. Swing's reading of the code is correct, would be precluded, but that's not what we're doing here tonight. We're here for the conditional use permit, which is a separate matter altogether. You've heard, again, illegal rezoning. I'll put the offensiveness of that statement aside for a second. You bet that the council did not go through an adjudicatory hearing for the rezoning. Of course they did. It's a legislative function. It's not an council does not sit as a court when they rezone a property. Council does not sit as a court or a quasi-judicial body when they do a text amendment to the zoning code. Council was amending the law. The codified ordinance is city law. Council can amend the law, whether it's zoning, whether it's purchasing, whether it's regulation of the public. We're talking about laws of the city, and council acts in amending the law. And the law in Ohio is very clear that zoning is a legislative function. We do add additional protections in the exercise of that legislative function. Some charters do, some city codes do, where they go through the process. You go to the planning commission for recommendation and to the and then you have the hearing before the council, or I guess in this case it happened both, where there were hearings before the planning commission and the council. But still, council was acting in a legislative capacity. And that question is not before the planning commission, and this is not the proper place. If they think that there was a something wrong about that zoning amendment, this is not the proper venue for that question. The proper question before you is whether this conditional use is proper, and we submit that it is. We submit that the burden has been more than met, well beyond meeting that burden. We submit that the party challenging the zoning hasn't put in, I think the witnesses that the opponent to the project has put forth have never been to the property.
I'll just object to the extent you're going well beyond the scope of my closing argument for purposes of a rebuttal. So I would hope you try and keep it focused on
I am.
not new material that you didn't think of the first time.
No, I am. I think you specifically attacked whether the witnesses that we have done their homework, and I'm responding directly to the witnesses doing their own homework. And to the point that one of the witnesses, the work was so sloppy that they didn't even do a proper due diligence. And the planning commission received a letter from her employer withdrawing her testimony and saying that her testimony was not properly before the court.
She did not withdraw her testimony.
Again, if I may finish the record speaks for itself as to what's before the planning commission. The point of it is you want to talk about the level of preparation, the level of knowledge. The witnesses that you heard from tonight know this county very well, know this city very well, know this area very well, know this site very well. They know their subject matters very well. None of them was conflicted. None of them failed to do any proper due diligence. And they were here to testify before you and gave you that testimony. And I think they're owed. You are the judge of credibility of witnesses, and you can render your opinion based on that. And with that, thank you very much.
Alrighty, I would like to also extend my heartfelt thanks to everybody who participated in these two-part proceedings. Whether that's witnesses that were here, whether that's council that was here, whether that's members of the public that attended, the applicant, the planning commission especially, thank you for sitting through the last two hearings worth of evidence. So at this point, I will now turn it over to the planning commission, and I'll remind you, as Attorney Swing noted, that you have to determine at this point whether the applicant and those sitting on behalf of the applicant in relation to the conditional use permit have shown by a preponderance of the evidence, i.e. more likely than not, and by substantial, reliable, and probative evidence that the issuance of a conditional use permit would be appropriate here pursuant to our codified ordinances. With that, I would ask that the Planning Commission present conclusions of fact related thereto, specifically as to 114502. And I would remind you that the Planning Commission may take one of three actions pursuant to our ordinances this evening. They can approve the conditional use application as submitted. They can approve the conditional use application subject to specific conditions, which we've heard this evening, or they can deny that application. And with that, again, I say thank you, and I'll turn it over to Mr. Dalpace.
Thank you, Mr. Boyer. I just want to remind the commission and just kind of run through, we're here, has been discussed many times tonight, chapter 1145, conditional use regulations. But I just wanted to point out, the main sections of that we are considering, 114502, conditional use and uses accessories to such conditional use shall be permitted in a district only when specified as a conditional use in such district. Only if such use conforms to the following general criteria, which are in addition to specific conditions, standards, and regulations set forth in 114503 through 114506. Planning Commission shall review the particular facts and circumstances of each proposed use in terms of the following criteria, and shall find adequate evidence that the use as proposed. I just want to run through these because some of these have been conflated along the way or defined incorrectly. So I just want to make sure that we all understand exactly what we're doing here and what we're voting on. A will be designed, constructed, operated, and maintained so as to be harmonious and appropriate in appearance with the existing or intended character of the general vicinity, and that such use will not essentially change the character of the same area. B will not be detrimental to property values in the immediate vicinity. C will not restrict or adversely affect the existing use of the adjacent property owners. D will be designed and constructed so all access drives, access points to public streets, driveways, parking, and service areas shall be in compliance with the regulations set forth in Chapter 1153. E will meet the requirements of EPA for stormwater runoff when applicable. F will be properly landscaped in accordance with Chapter 1155. G, the establishment, maintenance, and or operation of the conditional use will not be detrimental to or endanger the public health, safety, or general welfare. H, the hours of operation of the proposed use are similar to a use permitted in the district. I, the establishment of the conditional use in the proposed location will not impede the normal and orderly development and improvement of the surrounding property or uses permitted in the district. J, adequate utilities, access roads, drainage, and or necessary facilities have been or are being provided. K, adequate measures have been or will be taken to provide ingress and egress designed to minimize traffic congestion on the surrounding public streets. L, the establishment of the conditional use should not be detrimental to the economic welfare of the community by creating excessive additional requirements at public cost for public facilities such as police, fire, and schools. M, there is minimal potential for future hardship on the conditional use that could be resolved from the proposed use being surrounded by uses permitted by right that may be incompatible. And then I just want to go over the beginning of the next section because, there's been a lot of talk about conditions and can we approve things with conditions. I know everyone on the commission is familiar with this, but I just want to rehash that section quickly so that it's on the record and that everybody here understands. In addition to the general criteria established in section 114502, the following specific conditions pertaining to each use group of uses shall apply. A, supplementary conditions and safeguards. Nothing in these regulations shall prohibit the Planning Commission from prescribing supplementary conditions and safeguards in addition to these requirements in order to ensure compliance with the criteria set forth in section 114502, which I just went over. So I just wanted to be clear that, for everybody on the commission, that we understand what we are voting on tonight. With that, is there any other questions from commission members at this time?
Comments?
Comments?
Oh. Just, for the record, we did hear from a panel of experts at the last meeting that spoke on behalf of Acme, including an architect that didn't know the fabric of the neighborhood. Just for the record. We went through many challenges here based on the ordinances EPA compliance through voluntary mediation and design mitigation, traffic studies, financial commitment on accessory roads, access drives, turning lanes, traffic signaling. Most of these are covered under the supplementary conditions and safeguards. The one on financial commitment, I think Mr. McClure answered appropriately for me. One challenge I didn't expect was the financial impact on Acme as a business, which I consider competition. So I think that Meyer has met the burden, in my opinion. And Acme built in North Canton. I'm sure there were smaller stores that were impacted by that development. Acme wasn't denied that ability to go, and I don't think.
Any other comments, questions, Commissioner members? Okay. Well, I think with that, I would entertain a motion for this application number 22 NCPC-008.
I would like to make a motion to approve application number 22 NCPC-0008, Wolford Incorporated, 1445 North Main Street, North Canton, Ohio, 44720, a conditional use permit for a gasoline station accessory to retail parcel larger than 5 acres in the MS and G zoning district in accordance with ordinance 24-2022.
We have a motion. I would propose that we add the conditions brought forth by Mr. Van Gundy to add to those.
I'll accept that as my motion.
Okay, Mr. Van Gundy, do you have a copy of those? I'll just read these. So, as Mr. Sarah stated, there is a motion for application 22 NCPC-008, and we would amend that motion to include the proposed conditions of approval. Number 1, provide a final approval on the traffic impact study from the city engineer. Incorporate all conditions and recommendations from the final traffic study as approved by the city engineer. 2, stormwater quality quantity plans to be submitted for review and approval by Stark Soil and Water prior to any site work. 3, provide a recorded and fully executed Mylar copy of the recorded plat reflecting the minimum 5-acre parcel for the conditional use permit as per ordinance 24-2022. And 4, provide a wetland delineation study prior to the issuance of building permits and incorporate any required mitigation. I would second Mr. Sarah's motion. With that, we have a motion and a second, so I'll roll.
Mr. LePage,
Yes.
Mr. Mahousen,
Yes.
Mr. Dapes,
Yes.
Mr. Sarah.
Yes.
Okay. At this point, that concludes everything on the agenda for tonight's meeting, so I'd make a motion to adjourn. Do we have a second?